Maria, are you ready?
We are good.
Okay, the Behavior Analyst Regulatory Board meeting is convening at 9:08 a.m. on January 24th, 2020 at the Health Licensing Office in Salem. I will now call roll. Brenna?
Here.
Brad?
Here.
Megan?
Here.
Marie?
Here.
Corey?
Here.
Samantha?
Here.
Members, during the course of the meeting, please wait to speak until recognized. Once you've been recognized, please state your last name. Audience members are asked to sign in on the attendance roster, and public interested parties' feedback may be heard during the public interested parties' feedback period if indicated on the agenda. Everyone is asked to use appropriate language, manners, and protocols when conducting board business. This meeting is now called to order. All right, so first thing that we need to work on is approval of the agenda. So next to you should be some green laminated sheets that will help you with motions. But what I need is a motion to approve the agenda.
So moved. Legard, so moved.
And a
I
second?
second the motion. McMahon, I second the motion.
Okay, a motion has been made and seconded. Indicate with yay or nay when I call your name. Brenna?
Yay.
Brad?
Yes.
Megan? Marie?
Yay.
Corey?
Yay.
And Samantha?
Yay.
Excellent. Okay, the agenda is approved. Next item is introductions. So like I said, a lot of you are new. Some of you probably don't know who I am. So we're going to go around the room, talk about a little bit about ourselves and introduce each other. So I'm Sylvie Donaldson. I am the director here at the Health Licensing Office. I've been here for approximately 10 years. I was here when this board was created back in the beginning and worked with all through the legislation that created the board. So I've been here for quite some time. Okay.
My name is Heather Vogelsong. I am an Assistant Attorney General with the Department of Justice for Oregon. I provide advice to HLO as well as all of the different boards that it oversees. So I'm not your individual attorney, but I am your board attorney. And I have been working with the office for several years, but with the Department of Justice since 2005.
And I'm Bob Bothwell. I'm the Regulatory Operations Manager. I manage the inspectors for some of the other boards and the investigators for all the boards. And I've been here 9 years.
Okay, my name is Ann Thompson. I'm one of 2 policy analysts here at the office. I oversee about half of the boards and all the programs that we have. And I was brought on about 6 years ago, and this board was my very first one.
So in the back we have Maria. Maria, will you raise your hand? So Maria is currently until February 1st. She is our board specialist, and after February 1st, she will not be our board specialist, but she'll still help with the work until we get somebody hired to replace her. But you'll get a lot of emails from her. When we have longer meetings, like today's going to be, she'll send you some sort of what do you want to eat thing. If the meetings are not long enough to justify that, we won't do that. So sometimes you'll be on your own for lunch, so don't expect it to always happen. And then sitting next to her is Paige. So Paige is the administrative assistant for the whole office. She does a lot of the board recruitment, so you probably, in the very beginning, met with her or at least emailed back and forth with her. And then sitting here is Callie. Callie also does a lot of the board recruitment, and your bio is in the picture because she updates the website. So she has the powers to put your picture out there and all that other good stuff. And then she also does all the forms, and she works on continuing education stuff.
My name is Corey Stump. I'm a licensed behavior analyst in Oregon. I oversee footprints behavior interventions and have been in Oregon now for about 8 years. We serve areas of Vancouver, Washington, down through about Corvallis areas here in Oregon.
I'm Samantha Parnham. I'm a licensed behavior analyst in Oregon. I am the Chief Clinical Officer and founder of Adventures with Autism here in Kaiser. We provide clinic-based services for kids with autism, and we're just about to open our 2nd location soon.
I'm Dr. Marie McMahon. I'm a licensed psychologist in Oregon. I work at the Providence Children's Development Institute, providing evaluations and support services to kids and families with developmental issues.
Perfect. Brad's on the phone.
Good morning. My name is Brad Hendershot. I am a speech-language pathologist by background, currently working as an administrator with Oregon's regional programs, supervising services for children with autism, orthopedic impairments, traumatic brain injury. Yeah, that's about it.
All right, thanks, Brennan.
Brenna Legard. I'm the mother of a now 12-year-old with autism, so I'm the kind of parent seat on the board. I'm also an attorney. I've been here for a while.
Yeah. You're the most senior one on the board, I believe, at the moment. From November of 2015.
My name is Megan Johns. I am a behavior analyst, and I work for a company called Positive Behavior Supports, doing home and community services. And then I also own a business called Opening Doors that we do social skills for groups, social skills groups for children of all ages.
Excellent, thanks. All right. Okay, we're going to move on. So, like I said, a lot of you are new, so we're on item number 3. So, Heather is going to give an overview, and sorry, Brennan, you've heard this before, but I know, right? So, Maria, do you have her public presentation that you can bring up?
Thank you, Maria. So this is Heather Vogelsong. I'm going to stand because that's just how it makes me feel more comfortable as I'm doing the presentation. Let's see, some of you may have heard this before either through this board or through the governor's office or maybe in the media, but we'll go through different issues and look at a few topics. The next slide shows that we're going to be talking about public meetings, including executive sessions, which there's one on your agenda today. We'll talk about the board's authority, communications, including public records and speaking on behalf of the board, as well as some ethical issues. There is the Ethics Commission, and they are an independent body, and they are the ones that govern ethics issues, but we're going to touch just a few ethics issues that you may want to be aware of. All right, so we'll go to the next slide. First, public meetings. The public meetings law applies to you. The next slide shows that the requirements for a public meeting. What's important to know is that there's notice of the meeting, which HLO takes care of. The public needs to be able to access your meeting. That includes persons who have disabilities need to be able to access your meeting. And that these meetings are recorded. And that all of your votes need to take place in the official public meeting. So those are some guideposts. HLO usually does all of that for you as far as taking care of those things, putting out notice, making sure there's access to people, making sure that Maria is recording, or we'll be replacing her as recording. And then we always remind you and bring you back to public session for voting. Those are the basic requirements of the meetings. It's important to know that these are legal requirements that apply to your board meetings. So these must be dealt with for each meeting. Okay, next slide. Executive sessions. These are actually part of your meetings. However, executive sessions are times when the public is not able to attend. So there are certain subjects that you will be deliberating on when the public is not here listening to that. So we have the public step out and we tell the public when you would be coming back into your public meeting, so then they can come back and attend the rest of your meeting. But that executive session that you would be in would just be you discussing along with HLO staff. So those are executive sessions. They're close to the public. We go to the next slide. This is one of the reasons why you might go into executive session, and this is something that does happen a lot with the variety of boards that HLO covers. There's a statute out there called 676595, governs the confidentiality of investigative cases of different licensees, or non-licensees, but matters that pertain to the board. And for that reason, we would be going into an executive session to discuss things that the public cannot hear. So that's one reason why you would go into an executive session. So the other aspect of public meetings are things called non-public sessions. Those are different than executive sessions, which are laid out in statute for those reasons why you can go in and have those private, non-public conversations. This is actually not part of the meeting. It's considered not a public meeting. However, you're still talking about a certain subject as a board, and there are specific reasons in statute as to when you can have these types of meetings that are not public meetings. And there's different requirements that apply to that as well. You don't really need to know the difference between the two. Just know that they exist, they're out there, that there's reasons why you're going to be in a private session having discussions and why the public is excluded. And HLO will be taking care of the requirements as to what pertains to the executive session versus what pertains to the non-public session versus such things as whether it needs to be recorded, who can attend, what can be discussed. Those types of things are handled by HLO. Just know that they exist. The next issue we'll be talking about are communications. And we have two things that we'll be talking about under this. The first is that the public records law applies to you now that you are board members. So be aware of that as you are receiving communications from HLO, as you're working on board business. We'll go to this slide. The definition of a public record is pretty broad. Any writing containing information relating to the conduct of the board's business. The public's business. So that's a lot. Prepared, owned, used, or retained by a public body, which includes you, now that you're board members. And it is regardless of physical form or characteristics. So you could have a public record, something that is in an email or on your phone, in a text message. So there's a variety of different forms that would be a public record. An important thing to know there is that there are certain laws that govern what the public can have access to and not have access to in regards to those public records. But the main thing for you to be aware of is that this law applies to you, and so be aware of when you are conducting board business and that what you are creating is likely a public record. If you have questions about that, you can always ask Ann or Sylvie, and we can give you more direction. If there is a public records request for materials not going to incorporate materials that you've used or that you have created, then we would be working with you in regards to what will be provided to the person who's requesting it and what wouldn't be provided. Okay. The next aspect of communications is that you, as board members, need to be very cautious as to when you are speaking in your personal, private role versus your board member role. You don't want to be speaking on behalf of the board because the board collectively gets to make the decisions. You get to vote and you get to decide as a board as to whether you take action or not take action. Even if a vote is 6-3, you're still having that action be a board action. However, when you are out in the public, or if you are testifying in front of the legislature, or if you are in your role within your jobs, that is your own personal private hat that you're wearing, not your board member hat. So you need to be able to differentiate and remind people that right now I am wearing my non-board member hat versus right now I am wearing my board member hat. When you're here, you're always wearing your board member hat. You should not be thinking about personal interests, but what is in the public interest. When you are testifying before the legislature, if you do that, you would want to say, yes, I am a board member, but I am here in my personal capacity. I am not speaking on behalf of the board, because you don't want to get into a situation where someone is relying on information that you're sharing with them and thinking that the board would agree with you. There has been instances such as this backyard pool issue where information was brought up to a governing official, and the governing official was like, I don't see that would be a problem, I don't think you need a permit for that, something along that line, and the people relied on that. Turns out when the issue actually came before the board, before that commission, that they said, yes, you did need a permit for that. Oh no, we relied on this person's statement. Well, that person was not acting in as a board member. They shouldn't have relied on him because it's the board's collective decision. So just be aware of that. Make sure to just differentiate if you will. The next slide is board authority. So as you are all aware from basic civics classes, There are three branches of government. There's the legislative branch, the executive branch, and the judicial branch. You are part of the executive branch as board members. Legislature is part of the legislative branch. They're the ones who write the statutes. And the executive branch are the various different agencies and the boards, and they get to write rules. And then there's the judicial branch, the court system. So why is it important to know this? Because, we'll go into the next slide, you will get to be able to write rules on different topics. What you need to know for that are that your rules have to be within the intent and the scope of the statutes that govern the board. So what are statutes? Statutes are what the legislature creates. They have bills that go before them, and they go between the two houses, and the governor signs this bill into law. And then they are put into these books. They're also online, so you can find them. There are other versions of the laws as well. But this is what the legislature has said is the law. And there are laws that govern this board as far as what it can do, what it can decide, what HLO can do. There's lots of laws out there. What the courts have said is that agencies only have the powers that are given to them by the statutes. So we are bound by the statutes that create us. We always look to the statutes as guideposts, and we can't take actions that are contrary to the statutes. We'll go to the next slide. So what are rules? Rules are things that you, as board or HLO in certain aspects, get to create that interpret the statutes. And there's certain times when you get to create those rules and certain times when you don't get to create rules. But it holds the same power as the statute. There are laws that are created by agencies or boards. They're all grounded in the statutes. We always, again, turn back to the statutes. So the next slide, again, states that administrative rules have the same power as the statutes. People have to obey them. If that law applies to you, you have to obey it. Just like if you are driving in a car, you're a driver on the road, you must obey the traffic laws. So if you are a licensee under this board or someone who is registered as an interventionist under this board, you have to follow both the statutes as well as the rules that are created that govern you. There are different times, as I stated, when you get to create those. Some of it is policy related, some of it is because the statute tells you you need to create a rule, so different times. That's something that we would bring to you or that we would do on behalf of the board. One thing to remember in regards to the intent of statutes and the scope of statutes is that rules must stay within the guidelines of what the statute provides. So this is an example with pictures. So, and this isn't mine. I love this example. I wish I could claim this, but this is a fun example to go through. So we're a statute to say, here are the bones of a dog. And it would say, okay, board, go forth and put out rules on this dog. You could, as a board, create rules that say, okay, with those bones, we are creating this poodle. We are creating another type of dog. We're creating the dog that you just had. That came into your family. So you can create those different types of dogs because the legislature has said, here are the bones of the dog, now go forth and set out rules. However, you can't, as a board, create a cat because a cat can't be made with the bones of a dog. So that just gives you a visual idea of if the statute gives you these outlines where you have to be. You can be in the dog arena, but you can't be in the cat, even if you're cats. Okay. The next is just a little bit of information. As your board members, you're going to be hearing about laws, you're going to be making rules, and we'll probably be looking at statutes at some point or rules. And it's important to know how those are described, how they're referred to. So statutes have an ORS, it's called Oregon Revised Statute, so you'll hear ORS and then a number. And that's how we locate that different law, but that's how they're referred to. You know, it's a statute that says ORS. Rules are the Oregon Administrative Rules. Those are referred to as OARs. And then they have a big long number after them. So you'll know if there's a big long number, that most likely is a rule. Those are the differences. We'll go to the next slide. As board members, we touched on this a little bit in terms of communication. But as board members, you will want to keep in the forefront of your mind always that you are here on behalf of the public, acting in the public's interest. Not your own personal interest, not in regards to your profession, but in regards to what is in the public interest in relation to your profession. Okay. We'll touch just a little bit on some of the ethics rules that apply to you as board members. We'll go to the next slide. So who is a public official? It's you. Theirs is the definition. It's any person who's serving the state of Oregon or any of its political subdivisions or any other public body as an elected official, appointed official, employee, agent, or otherwise, irrespective of whether the person is compensated for the service. So welcome. You now are a public official. Now, with being a public official, there are certain laws that apply to you in regards to ethics. So we'll look through a few of those. The first one that you'll want to know about are conflicts of interest. There are two types of conflicts of interest that you'll want to be aware of. One that is an actual conflict of interest and one that is a potential conflict of interest. The actual conflict of interest is on this side. What's really important in here is to focus on the word would. It's any action, decision, or recommendation by a person acting in a capacity as a public official, again, you, that would result in a private financial benefit or detriment to the public official's relative, so your husband, your child, public official's relative, or any business with which the public official or relative is associated. So again, the word would is very important because it means that the financial effect of the action would occur with certainty. Okay. Different one is the potential conflict of interest, and that's on this side. I'll go over here quick. Any action, decision, or recommendation, again, that same type, scope of information. And again, it's you by a person acting in a capacity as a public official. The word here that's important is could. That could result in a private financial benefit or detriment. Focusing on both the benefit and the detriment is important to remember. And again, it applies to both relatives as well as businesses. And again, focus on that word could, and it means that the financial effect of the action would be uncertain. Okay, so if you have identified that there is a private financial benefit, then you have to go through, or detriment, then you have to go through an analysis. We'll turn to the next slide. This is what you would want to be thinking of. Can the result of my official action, decision, or recommendation financially affect myself, a relative, or a business with which either are associated? When that comes into your mind, if the answer is yes, then you go and you say, oh, are there any exceptions that would apply to me? And there are a list of exceptions. We're not going to go over that. Because if you get to yes, you're probably going to want to talk to someone at that point. You're probably going to want to inform Sylvie and Anne, and you may want to reach out to the Ethics Commission at that point because they are the ones that are going to be guiding you as to whether there is an actual or a potential conflict of interest. We can provide some information on that, but it's the Ethics Commission that are the ones that enforce the laws, that would be able to find you in violation of a law, and the ones that would be able to advise you as to whether it is actual or potential, and that you could rely on them, so that if you do later get investigated for something, you can say, I relied on what they told me. So it's in your benefit to be in touch with the Ethics Commission when that first answer is yes. Then they would be able to help you through whether any exceptions apply. And then the next question is the, whoops, sorry, can you go back? Is the resulting financial effect certain or uncertain to occur? Okay, so when you're in that situation, just know you're going to need some more information at that point in time. The next slide shows that even if there is an actual or potential conflict of interest, that does not mean that you are definitely excluded as a board member. There are certain steps that you need to take under the law in order to comply with the law, and it depends on whether it's an actual or potential conflict of interest. So again, that's why you need to be thinking, what is it a would or a could situation? So you need to make a public announcement on each occasion, every single occasion, before taking action on the matter. So if there is an actual or potential conflict of interest and it relates to a rule that you're working on, then at each meeting where that rule comes into play, you want to make your public announcement on each occasion before you take action. For actual conflicts of interest, as a board member, you would need to refrain from participating in discussions, debate, or voting on the issue. So all three of those things. You couldn't debate it, you can't discuss it as a board member, you just have to sit there with your mouth closed. You wouldn't be able to vote, unless, there's always an exception, unless the vote is necessary to make a quorum that is needed to take official action. Then the public official with an actual conflict of interest may vote, but must still refrain from any discussion or debate on the issue. So again, there are steps that you would need to take if there's an actual or potential conflict of interest. The most important thing is being able to identify when you might have an actual or potential conflict of interest, and then know to go and get more information and more help, and then we can help you through the rest of the steps, as well as the Ethics Commission would help you through the rest of the steps. Okay. All right, next slide. You can't use your position for financial benefit or to avoid financial detriment. So this applies to you, your relatives, members of your household and businesses, and people that you are associated with. And also know that the law defines what's a relative and defines what's a business associate. So again, if you're getting into a situation where you're saying, I think this applies to me, that's where you need more information so that you can go and we can look at whether it is a relative, whether the business falls within the statutory definition, that sort of thing. So these are just kind of like, oh, this is something I need to be aware of. Oh, this is something I need to be aware of, so that then you can go and get further information. Be aware, however, that you cannot use your position for financial benefit or to avoid financial detriment. Very important. Okay, next slide. In addition, as a board member, you are going to have access to confidential information, whether that information is confidential because it relates to a case or because it's attorney-client privileged information. You would have access to it as a board member. It's information that the public does not have access to. As a board member, you need to keep that information confidential. You need to keep it private. So you wouldn't want to leave information that's confidential out on your printer or out on your counter where others would be able to see it. You want to make sure that you're being very careful to not talk in the public or with others about information that you hear in your board meetings that are in private. The last piece of that was to not solicit or receive promises of future employment for taking an official action. So if you are getting ready to make a career move, keep that in mind. If you have questions, then again, you would want to seek the benefit of talking with the Ethics Commission, talking with their staff to get more information. Again, this is just to give you some eye-openers as to what's out there, things to be aware of. Ultimately, as a board member, it's a very exciting job. We're excited that you're here and participating and helping the public. And just remember that you are acting in the public's interest when you're here, to be very careful to, when you're out in the public, differentiate whether you are in your board member role or whether you're in your personal role. And then also remember that there are additional laws that apply to you in regards to ethics, and you can always ask for help. Say, I think I might be entering into this territory, and HLO will direct you to the correct person to talk to, including whether that is the Ethics Commission or to me. Okay. All right. Thank you.
Okay. So this is Sylvie. Marie, we get back over. Yep. We are on item number 4. So, like I said earlier, we did not previously have a chair and vice chair because there's so many of you who are new. And then we had today's meeting, and we have tentatively scheduled, as long as you guys are okay with it, then we'll vote on it, but next meeting for July 17th, which is a Friday. I don't know if any of you want to get your calendars up and running. I have the calendar if July 17th does not work for everybody, but you have to remember you're also one of 16, so we got to be careful when we try and move things around. So I don't know if there's any national conventions during that time. If we do the same time, so it's always going to be a Friday at 9 a.m. So unless they hear otherwise. If someone could make a motion to approve the meeting date for 2020 of July 17th.
This is Brenna, so moved.
This is McMahon. I second the motion.
A motion has been made and seconded. I will call roll, indicate with yay or nay. Brenna?
Yay.
Brad?
Yay. Yay.
Megan?
Yay.
Marie?
Yay.
Corey?
Yay.
And Samantha?
Yay.
Okay. Next item is chair and vice chair. So there is a little memo here. You're welcome to read it. For those of you who are new, you're basically doing what I'm doing right now. But don't get stressed out because I'll help you through it. But you do need to elect a chair and vice chair because both the the two individuals who are chair and vice chair are no longer on the board. So, and I don't know if you guys can talk about it, see if anybody feels comfortable doing it. Some people don't like doing it. But ask questions. Every once in a while we will contact you if there's information that we need as chair. The chair also reads the scripts that I'm reading now, usually runs the meeting. I obviously will help at all times so that you don't forget to say something. And we print out all the scripts for you so you don't have to memorize anything. But is anybody willing to volunteer? Anybody willing to be a chair or vice chair? Somebody has to do it, so you guys can figure it out.
I'm willing to do it. I don't know if I'm the best choice because they don't answer my email. But
Well,
I can read stuff.
Yeah, Brad, you've been on the board for a while too. Are you feeling comfortable if somebody nominates you to be chair or vice chair?
I have a little ambivalence given the role that I play as a public member, not being a BCBA. I just kind of have mixed feelings on that account.
Okay, and that's totally legitimate. But again, one person does not get to make all the decisions at all. The board has to vote on every decision being made. So you have to vote on the agenda. You have to vote on everything. So even if, I'm not saying Brad obviously doesn't sound comfortable doing it, but even if you were the public member and the chair, doesn't mean that you have any more power than anybody else does.
Right, of course.
Yeah, but it sounds like Brad's not comfortable with that. So
if I was in the room, I'd be like, glaring at certain people, encouraging them to step forward. I can't do that because I'm not there in person. I'll have to be there in person next time.
Oh, you guys are funny. You have to have a chair and vice chair, so you guys need to talk about it.
I think it's hard because so many of us are so new to the board.
I wonder if maybe you unpacked a little bit, kind of, because sometimes it's for folks it's a bandwidth issue and knowing what their other commitments are. So, like, what's the kind of anticipated time commitment associated with the chair position and vice chair?
So, time commitment is you have today, the rest of today, and you have July 17th. And at July 7th, unless there's no other meeting scheduled, which we might schedule another meeting in there depending on how item number 8 goes. So you basically have to be at the meeting. I may call you randomly here and there if I have a question, but that doesn't mean you have to attend, you just have to answer your phone. And so the commitment is pretty much no more than basically participating in the regular board meeting. The downfall is that a lot of people get really nervous, have to read or to run the meeting. But you have to remember that I'm here, I do this pretty much 3 times a week, so I have it down pat, and I will make sure that whomever does it
And it's best that, this is Ann, it's best that you're here in person.
Yeah,
Because
yes.
being on the phone and reading scripts and not being able to see people
Yep.
is pretty impossible. So if you come
Yeah.
from a long way or commute is difficult or whatever, and you anticipate having to take advantage of the teleconference option, you may want to think about that.
So I
Well, I mean, I've chaired groups before, and I would be happy to help, but I really think that, I don't know, it just seems appropriate for a BCBA to chair this particular board.
Looking at you, Meg.
This is Megan. I guess that's me.
definitely at the head of the table.
Yeah, there you go, Megan. Good job.
I'll
Megan,
vice chair if you chair. If anybody wants me to, which nobody needs to want me to.
Yeah, I would be willing to do it.
So it sounds like, if nobody else wants to do it, that Megan for chair and Brenna for vice chair. Somebody could make a motion to that effect.
This is Brad. I'd like to make a motion in that effect.
Is there a second?
This is McMahon, I second the motion.
Okay, a motion has been made and seconded. I will call roll, indicate with yay or nay. Brenna?
Yay.
Brad?
Yay.
Megan?
Yay.
Marie?
Yay.
Corey?
Yay.
And Samantha?
Yay.
Excellent. Sounds like you're the chair. Okay. So we'll move right along. We are now on item number 5. So director's report. Only a couple little things that I have. We're getting ready to start session again. So it's the short session. It only lasts about 35 days, which is really fast for laws we pass. So when Heather was talking earlier about statutes and statute changes, normally major changes get done during a long session, which is always in an odd number year. A short session is in an even number year. And usually, not always, short sessions are intended to fix things or to address budget issues. However, we have 3 bills that are coming up, 2 of which are fixes, 1 which is a new program to us. And the reason it's coming during a short session is because of some technical things that occurred during the long session. There's timelines by you have to have been heard over in the House section by a certain time or the Senate section. So there's timelines, and if the bill doesn't meet those timelines, they call it that it's dead. It's a dead bill. There was no issues with the bill, except for the fact that they didn't have a work session by the cutoff, the deadline cutoff. It might have something to do with all the protesters that were downtown, but we'll see. So anyway, so that's now coming. So genetic counselors is going to be a new program that will be added to us. So there's going to be roughly, I think about a little less than 100 of them. But that's a new program, so that'll be a bill that I'll be downtown working on for a new program. So that means there'll be 17 working programs. And there's 2 other ones that are in the works. One is for long-term care, and one is for the Board of Cosmetology. And then we have some housekeeping stuff that we're trying to get moved forward, but that may have to wait till the long session. So those are the only updates I have. So any questions about legislative stuff? It won't affect you, but that doesn't mean that something may not in the future. So so Heather kind of touched on it a little bit, but we always have no position on any legislative stuff. What I do is say, yes, I can do that, or no, I can't do that, and here's why. I do not have an opinion on whether or not legislation is passed or not passed. I'm just there to say, yes, that will work within our structure, or that is something that we can do. So there was some legislative stuff that does relate to this board. I will always be a part of those conversations, but again, I'm neutral. That does not mean that you as individuals cannot participate in any way, shape, or form. You just need to clarify that I'm doing this on behalf of myself and not as a board member. We encourage you to be very involved in legislative stuff. That's as long as to get changed, but you can't do it as board member. Does that make sense? Okay. Because I am pretty sure that since this board was created, they've had a legislative something started every single session. So the odds of another thing coming up are probably going to happen. And during public comment, you may hear some updates on that. So moving right along, let's go to some reports, and I'm going to go through these. I've looked at these 101 times, so I don't have any questions, so stop me if you do. Sometimes I go through it kind of a little too fast because Like I said, I've looked at them 101 times. And sorry, Brad, we're on the phone, we're on the slide that talks about the licensing statistics. So it just has the numbers broken out by quarters, so that's where we're at.
Okay, thank you.
So state government has its own calendar. We don't follow like the regular calendar like anybody else does. So these numbers get a little confusing. So when you're talking about quarter 1 of 2020, that is actually July, August, and September of 2019. So it gets a little confusing. Because our year starts July 1. Yeah. And then they always use the end of the year, which would be June 30th of 2020. So that's why it gets confusing. Does that make sense though? Okay, so this is how many behavior analyst licenses we have issued, broken out by quarter. How many assistant analyst licenses we've issued, interventionists, and then the total. Any questions? Okay, next slide. So this is the trend. So this is on average, broken out by quarter. So again, here's your fiscal year 2017. So this is July, August, and September of 16. And then here's where you are, and this is an average now. This line here is way larger than we ever thought in many years it was going to be. These two are pretty almost identical to what we were told was going to occur. That one, not so much. Make sense? And it's still growing. One would assume eventually it would start to level off, but we'll see. But look at this. This is the growth. I mean, it's just skyrocketing. So we'll see how far it goes. Next slide. So I have asked, and there wasn't time to do it, but to me, this slide is like pointless because it's skewed so much because it's combining all 3 license types. So what I want to do is break it apart into the 3 different license types because your interventionists are the youngers, and then your analysts and assistant analysts are farther up in here, so I think it's kind of skewed. So your next slide will have this broken out into the 3 different categories. Back up. So, and I know that's hard to see, but individuals do not have to identify whether they're male or female, which is why you have green, blue, and that. This is like a yellowish, I was going to say baby, you know what, yellow. But that's what that is. So that individual, this is broken out by age and gender. Does that make sense? But again, you do have to give your date of birth, and you have to give your social security number. You do not have to give your gender if you don't want to. Next slide. So this is as of January 22nd. This is the actual number of individuals. So there's 1,644, I think that's a 6. Is that a 5 or a 6?
It's a 6, I think.
Marie, is that a 5 or a 6?
It's a 5.
It's a 5. Okay. 1,544 interventionists. That's a lot. And then you have 18 assistant analysts and 282 analysts. Next slide. So this shows your financials again, the weird calendar month, which it says up on the top. So then it's broken out by our years, which are deceiving. And then here's your assessment. So I'm going to go through these so that everybody understands. So each board has their own set of revenue and their own expenses. There are certain things that are what we call direct charge, what we could directly tie to this board. And then there are certain things that are indirect charges. So for instance, my salary. So we do not get general fund in any way, shape, or form. All the revenues that we get are all from the 16 working programs that we have, and it all stays in-house. And then every July, we reevaluate where the office is at, how many licensees we have, how many boards we have, and all that kind of stuff. And then we do we call it an internal allocation. So that internal allocation is readjusted every July based on the fact that we keep growing. And so your percentage will change. So this is your percentage. So you pay 0.4% of the cost of having me. Does that make sense? And 0.4% and then 0.5%. And part of the reason that this will go up is because your number of licensees keep going up. So you will actually have a bigger portion than we anticipated because you're having more licensees. But having more licensees means more revenue. So does that make sense? Okay. Small board assessment, so we have 3 individuals who work on a small board. And small board is considered anything but cosmetology. Cosmetology's got like 60,000 people in it. So yeah, so they're kind of like in their own little pool. So of those 3 individuals, you guys pay a little over 5% of them. Does that make sense? Because they only work on the small boards like you guys. Examinations, you pay none. So those of you who came in and saw that room that's out there, we have a testing room where people can come in and take tests. We administer the tests, we create the tests. This group does not have a test, so you don't have to pay for any exam-related stuff. Does that make sense? That's why it's all zeros. And then inspections. Inspections are where we have 5 inspectors that go out and inspect facilities. So there are only 2 boards that have that though. Cosmetology is one of them. And then your tattoo and body piercings. So those are the 2 boards pay for those. So they pay for the cars, the people, and all that kind of stuff, because that's what they do. That's what they do all day, every day. But you guys are paying that because you don't do inspections. Make sense? Does that kind of understand how everything works then? So we try to break out and make sure that you're only paying for the services that you use. Some things you just have to, like rent. If rent's one, you're paying that 0.5% of the rent. Okay, so that makes sense? Any questions on how that works? Okay. And then your cash is your cash. One thing that this can get affected really quick when we get to your agenda item number 8. If one of those cases end up going to a hearing or going to, they call them hearings, but it's kind of like a trial-ish, that money will go really fast because that is a direct bill that's directly related to this board and this license type, and those get really expensive. So one of the things that we want to always have is a cushion to cover that in case it happens. We hope it never happens. And if any of you read the newspaper, you know that things do happen. So, and we have the authority, the office and this board have the authority to revoke somebody's license and to take their license away from them. So they're going to fight that if they feel that we're doing it wrong. And that's where it will go to, it could go to a hearing and get really expensive really fast. Make sense? Okay. And there's a lot of new information for you, but you have questions about any of it? Okay. All right. Let's move on to regulatory.
Good morning, this is Bob for the record. We've got 2 biennium up on the board, 17 and 19 biennium. We had a total of 13 complaints that we received. 4 remain open, 9 are closed. And in the current biennium, we've had a total of 12, 8 remain open and 4 are closed. Sorry, go ahead.
No, I was just going to say, and like we've said before, obviously we're not going to go into the details of cases unless we're in an executive session. So I know that this is not a lot of great information, but the information is confidential, which is why we don't put it as part of this. So I know this doesn't, doesn't give you a lot of answers, but we want to make, we're very transparent. So this is how many cases we've received, how many are still open to this day, and then how many we've closed.
And in the lower left corner, it's how the complaint comes in, anonymous, a client, or other.
And other could be mandatory reporters, it could be the office initiates an investigation. It could be,
Another professional.
Yep, it could be, we also get, not necessarily always for this board, but we get complaints that come from other regulatory bodies that they say, hey, somebody's doing, like, big one is denturist and dentists. They're 2 different professions, 2 different boards. And so people will send a complaint to them and they're like, that's not us, it comes over to you. Any questions? Move right along. All right. We are on policy. Ann.
Thank you, Sylvie. Again, for the record, my name is Ann Thompson. At the last meeting, that quite a few of you were not here. I feel like a television announcer. When we last met, we had a conversation that led to the board wanting to remind licensees that they are expected to abide by our laws and rules. There was this desire to remind folks. And so, because I do what I'm told, I sent this out. And it wasn't singling anybody out. We just said, you choose to become licensed with us, remember, you're bound, as Heather pointed out, by our laws and rules. what was really interesting, you never really know what kind of a response you're going to get when you send out one of these communications. And I got a lot of phone calls from folks that were like, hey, did somebody say something that made you send me this? Am I okay? And the question is, I don't know, are you okay? It went to everyone. So there it is, and we can do this. If if the boards feel that there's something maybe new in the practice, we don't do, and this is kind of a great segue, we don't do what we call scope of practice questions. Because again, we have 16 boards and programs with numerous professions. I think, what do we have, 22 professions or something? And we get people that call us up all the time and say, hey, can I do this thing? We do hearing aids. And I've had people call me up and say, hey, I've got a client here with a cochlear implant and the wire's hanging out. Can I change that? What? We don't offer individual advice. And we say we don't give legal advice. When people call up and say, I have an individual circumstance, can I do this? We don't. If I looked at this, the laws, and said, yes, you're okay. Number one, how do I know you're telling me the right thing? Number two, if you're calling me, my experience is you probably shouldn't be doing what you're doing. And I can't practice the law. I can't do that. However, if there's something going on in a profession that's affecting everyone, or if a board thinks a gentle reminder would be suitable, we can certainly pull a list of licensees and put a letter together. An FAQ is really popular, something we can put on the website and send people to, maybe that's affecting the entire practice, or to remind people, hey, I know you're with the National Association, but you're also beholden to our codes of conduct, codes of ethics, and that sort of thing. So, here we are.
Any question? Oh, you guys are easy.
I know, they're so great.
All right, we're on item number 6. So we're going to do public interested parties feedback. So at this time, the Board of Behavior Analysts Regulatory Board, Behavior Analyst Regulatory Board, will hear public interested parties feedback. Members of the audience, please wait to speak until you've been recognized. Once you've been recognized, please state your name and affiliation to the board, and I would also like you to come sit at the end of the table so that we can get you on recording. So I have, Megan. Would you like to read all this stuff that I just read, since you're the chair? Do you want me to help you here? I forgot we're supposed to pass this over.
I thought you were just going to continue to do it.
I know, right? That's the easy thing. Yeah. So here's the script that I just read was right here.
Okay.
And here's the sign-in sheet.
Okay.
And so Hannah has signed in, but she has indicated that she would not like to comment. And Hannah, are you still not wanting to comment?
No, I don't want to comment.
Because they could always change their mind. And then Paul Turdall also signed in, and he said that he would like to comment. So Paul, you want to come up to the table so we can get you on recording? Maybe you'll be okay.
So, ready?
Yep.
Great, okay. Hi, so my name is Paul Turdall. I'm a consumer, so I'm not a licensed behavior analyst or an attorney. I have 2 children with autism who receive behavior analytic services from people licensed by this board. And I had a very active role working with Senator Bates and some of you in developing the legislation which created this board. Because of that sort of history that I have with the legislation, many people come to me for input about the legislative history. I do not give people legal advice because I am not a lawyer, but people do ask me for my insights on basically how we got where we are. As I discussed with this board, I guess I just sent as I have communicated with this board in the past, there are some gaps in the regulatory structure for behavior analysis. Specifically, strictly speaking, the Health Licensing Office has regulatory authority over people that are licensed and registered. You don't specifically have authority over people who are not licensed and registered. When I say we, I mean Senator Bates and myself and the Legislative Council and other people who are working on Senate Bill 696, which created the current structure of the board. well, ancient history, Senate Bill 365, when we first created the board, we never actually said this board had anything to do with ABA at all. That was somehow missing from the statute entirely. We just created this board and never said what we were licensing people to do. When we rewrote the statute in 2015, we clarified that people that you license are permitted to practice, are allowed to use the titles that you confer, and we also said that they're specifically permitted to practice ABA. We did not grant you authority over the unlicensed practice, partly because that was an emerging issue, and it is already unlawful in the state of Oregon to provide any sort of healthcare or psychological service for any sort of mental health condition. That was already illegal. We didn't have to make it illegal, it already was illegal. The problem we have is a policy matter, and that is that you now have a large board, a large number of licensees and registrants. You just went through the numbers. And the question really is, how do we address that? This hit home to me really hard a couple of years ago when an attorney informed me that an unlicensed, unregistered person had raped a child in the course of therapy. And as that has developed, it hit home harder when the defendant called me up and asked me for my advice on whether or not her practice of ABA was illegal since she wasn't licensed or registered. And in subsequent discussions with the district attorney's office, who was prosecuting her, with the victim's family, with a number of other people who were involved in that particular case, it really became clear that there was a regulatory gap that needed to be addressed. And we tried on a sort of a rush basis to deal with it last year in Senate Bill 135 and on a last-minute amendment that wasn't properly vetted, that didn't go. I've had subsequent discussions. About 2 weeks ago, I met with the Board of Psychology to discuss it. We had a very long discussion on the record about just generally the issue of this. And the Board of Psychology generally acknowledges that they have authority over the unlicensed practice of psychological services. They generally acknowledge that ABA services, when used to treat mental health conditions, can be within their scope. As a policy matter, they don't want that job. They do not want to be dealing with the unlicensed practice of ABA because you just looked at your financial numbers. It's expensive. There are a lot of people who are doing this. They would rather that be delegated to this board. They specifically asked me to work on developing legislation that would grant this board the authority over the unlicensed practice. They specifically, on the record, specifically stated that they would like to endorse such legislation and that they would like to ask the governor to support such legislation. They offered as individuals to help write such legislation. They offered use of the mental health regulatory agency staff to provide technical feedback on doing it. So I think that is something that should be addressed. They did also state that if somebody were to file a complaint about unlicensed practice of ABA with them, it was the DOJ advising them, I forget the name of their assistant attorney general who was there, basically spoke up and made it very clear that if somebody were to file such a complaint, they would look at that on a case-by-case basis of precisely what it was they were doing, and they could very well take enforcement action. They also suggested, just to help things along, that they could issue warning letters to people who were practicing ABA without license, saying, if you don't get a license spot from BARB, we will have to do something. And so that they offered that as something that they could do to help out. So I think a couple of things that I would suggest. First off, because we have this current gap where it is illegal to practice ABA if it is done for the purpose of treating a mental health condition like autism. That's already illegal, but the enforcement gap is not something anybody wants to do. So I would encourage you to coordinate with them, and we discussed this with the Board of Psychology, on some kind of letter like the one that we just saw, that might be a joint letter between this board and the Board of Psychology, basically just spelling out that the unlicensed practice of any sort of therapy to treat any sort of mental health condition is unlawful in the state. And I think if you were to do that, that could be a very good reminder that might help just close the gap and help people understand they actually have to get licensed to get something. And I think that alone, I think, would probably solve 95% of the problem. And then if that wasn't enough, a follow-up warning letter from the Board of Psychology letting people know, look, we actually meant it, go get your license from the BARB. That, I think, would really help. And so they didn't commit specifically to doing that, but we did have a good discussion about that, and they brought up some of these ideas in the meeting. So I think that would be something to follow up on. I think in addition to that core issue of the who takes responsibility over the practice of unlicensed practice of ABA, there are a number of other issues that people have brought to my attention over the last few months, which have sort of raised questions for me about just miscellaneous gaps in the regulatory structure that ought to be looked at. Currently, as I understand it, DHS is investigating a complaint against the behavior analyst, one of your licensees, over improper use of seclusion on restraint, right? Specifically restraints. I think the issue that I am hearing is that DHS does not necessarily have authority there, and that your own administrative rules are relatively vague about when use of restraints is proper and how they are done. It's all in the BACD code. So it's there, it's just pretty unspecific relative to how the rest of the state of Oregon looks at seclusion and restraints. And I think that is something that this board should probably take a look at in terms of revising rules. Should you be more specific in your rules on restraints and on reporting restraints and things like that, so that it's more consistent with what the rest of the state is doing. Along with that, the same person who raised that issue also brought up questions about licensing and registration of facilities that provide health care. Your licensees are licensed as individual providers. In most other healthcare professions, there's also a separate license for facilities, particularly like a home-based healthcare facility. Having looked through the regulatory structure for home-based healthcare and discussed it with some attorneys who have an interest in the issue, it's clear that Oregon's laws on home-based healthcare were not designed for ABA. They talk about all sorts of restriction requirements on it, like you have to have a nurse on staff and things like that clearly are not appropriate for you. But it's not clear that behavior analysts who provide in-home services are actually exempt from the statute. And I think those are things that ought to be reviewed to either make clear that you are exempt or to adjust the regulatory structure in a way that it is useful. Along with that, there are just a lot of other things that the state of Oregon is working on related to behavioral health care and behavioral health treatment that have no connection to this board at all. You have, I think, one of the largest bodies of licensees and registrants who are providing behavioral health services in the state, and yet a whole lot of groups and issues working on behavioral health care have just, not accounted for you or addressed them. There are task forces on behavioral health care that have no licensed behavior analysts on them. There are all sorts of policies and procedures that apply to behavioral health care that will have a long laundry list of all the providers that are included: psychologists, LPCs, LCSWs, and licensed behavior analysts are just not listed. And I think that is a kind of thing that simply ought to be reviewed and looked at, just to see, okay, should we be sticking a licensed behavior analyst in here in different places? I have a specific laundry list there. Two final things before I wrap up. One, we discussed, or I submitted, and you all discussed in September, school-based ABA services. These 4 years ago now, the Oregon Health Authority offered a state plan amendment to specifically include licensed behavior analysts as Medicaid use as providers that Medicaid could reimburse for school-based health services. That has basically stalled, and I think that would be a really critical thing that would provide some significant funding. The second is Senate Bill 365, which is a autism mandate that includes ABA, sunsets in 2 years. So January 1st or 2nd, 2022, it goes away. And we need to make some strategic decisions for whether or not we want to do anything about that, whether we should just let it sunset. We are currently operating under the mental health parity statute from 2005, so we may simply not need it anymore now that we have that clarified thanks to AFP Providence. Or we may want to remove the sunset, or we may want to clean up the bill and fix issues. So that is out there, and one way or the other, we need to do something in the 2021 session, or by default, it goes away. So I'm not here with like a specific bill. I think there is a reasonable, it would be a good idea to work on legislation for 2021 that addresses some or all of these issues. As I said, the Board of Psychology has specifically offered to endorse it and to ask the governor to endorse it. And I would be interested in any comments from this board if this board would like to have a role in that.
Sylvia will answer that one. Sylvia will be participating with it, but without a position. So I'm Switzerland. So like I said, I will participate and I will tell you if the verbiage will work. But we can't be bringing any kind of legislative concepts forward, which is how, for those of you who don't know this, a legislative concept is how a bill becomes a bill. So it starts as a concept first, and so it actually will say LC on it and a number, and then it gets changed as long as it gets endorsed, then it will become a bill, and then it moves through the process. So we are an office under the Oregon Health Authority, and the Oregon Health Authority has a director called Alan, and he gets to decide what bills go forward. And how it works with us is that the associations or a group, whether it's an association or not, a group would then bring something like this forward. I would be a part of that group and saying, yes, we can do this. You might want to think about this. Here's a better way of wording this. Get it covered, whatever your intent is. Like the intent about making sure that individuals who are not licensed cannot practice ABA, because that sounds like one of the #1 priorities that needs to get fixed. And so we have other statutes. So I would be helping with the verbiage on, if this is what you want, this is the best way to say it, kind of thing. But we would not be bringing a legislative concept forward. This board would not. Does that answer your question? But it doesn't mean you can't as an individual. As an individual, get into groups, but not at this board. And you can't, 4 of you who are on this board cannot get together and do it, because then you're now a quorum. 5 of you. So if 4 of you want to do it, that's okay. But once you get 5 of you in a room together, you're all on the board, and that's a quorum. Make sense?
So okay. This McMahon, just to clarify, so you're saying that the board cannot work collaboratively with the psychology board on this?
So there's certain things that the office can do. So okay. I made notes, because I'm always listening to what he's saying. So I made notes about, we're going to go and listen to the audio of their board meeting.
Okay.
The other one is talking to their AAG about,
okay.
You have to remember that we have statutes and they have statutes. So just because we want to do something and we want to do the right thing doesn't necessarily mean we can.
Okay.
So sometimes we can't do something because the statutes don't allow us to do something. So these are some conversations that we're going to have behind.
Of course.
Yes.
Right.
So I made a whole page.
Okay. So it sounds like, assuming that some of the same rules, statutes, and laws that govern the Board of Psychology and their ability to facilitate this type of oversight of unlicensed practitioners, assuming that those same things are in place for here, it is something that we would be able to discuss during the executive session, I'm assuming? Okay, Roger. Thank you.
So, I mean, so I've been working with Paul, others work with Paul on various and sundry things, and that involves speaking with the legislature and having meetings and stuff like that. And so whenever I testify with the legislature, I always start with, I'm a member of the BARB, I'm here in my individual capacity, I'm not here on behalf of the BARB. And that's all you need to do. So, Sylvie's point is obviously well taken, but...
And I'll be in the room. She testified last...
That's right.
Yeah.
And Sylvie didn't yell at me or anything.
No, and I didn't have to say anything either. I mean, you sit there in case a legislator has questions. So if a legislator is listening to what they're saying and saying, Sylvie, can you implement this? Then I would get up there and I would say, yes, we can implement this, or, But the other thing that they, meaning legislators, want is for us to have all worked that out prior to them going up and testifying.
Sure.
So that's when Paul is talking about talking to the Board of Psychology, getting everybody on the same page, because you don't want to go and bring legislation forward that then has a whole group that's like, hey, wait a minute, we don't want this. So that's why he's working on stuff now, because the intent is when you go up there and you talk to the legislators, everybody's all on the same page.
Sure.
So.
And there's, so in our world, right, there's also a RABA, which is the professional organization in Oregon of behavior analysts, and and they've, I'm going to say this because I can, because I'm not a BCPA, they've at times had a little bit of trouble coming up with a position and sticking to it for any length of time. But you all are on the BARB, right, and presumably, RABA members, all of you who are BCPAs, right, and so, that's kind of another aspect of your political, policy, lives, and an important part. When we worked on trying to get, so the problem is, to make sure that you'll understand that the problem with the unlicensed providers, right, is like I could set up a shop that said, Brenna's behavior therapy, and violate every one of our rules, and not get licensed, and it's unclear that anyone would stop me, because I wouldn't have submitted myself to the jurisdiction of this BARB or the PACB or anybody else. And so near as we can tell, the only people who have the power to stop me would be the psych board, and they're a little ambivalent about doing it if I'm calling myself a behavior analyst, even if I'm not. So we have a gap. We try to fix it in legislation, and the stakeholders weren't really aligned. And one of the bigger stakeholders that had a problem with what we were doing were the school districts, because as they, baby step their way into embracing ABA in a school setting, they don't want to be bound by rules that they don't have to be bound by, or they feel they shouldn't be bound by. And so the school-based ABA therapists are kind of in this sort of weird limbo, working for organizations that are still really trying to understand what they do, and who don't understand the rules that bind them, and they're sort of figuring it out on the fly. And so to be perfectly open and candid with you, so I previously alluded that my son, who is now a 6th grader, has had a pretty rocky entry into middle school. The school really wanted to, the school staff really wanted to use the expertise of his BCBA, but Portland Public School policy prohibited them from doing that, because Portland Public has said no private therapists giving therapy in our settings. And so my kid cratered, the staff pulled their hair out, a dumpster fire ensued, while the private BCPA stood there unable to do anything about it. And we all, anyway. So Portland Public employs some private behavior therapists, or employs behavior therapists, but it was unclear how we would access those services for our son. And so, we followed the 15 different nonsensical leads that they told us to follow, and none of them led anywhere. And we eventually sued, and that lawsuit is still pending. So after we sued, just coincidentally, the district figured out how to provide a school behavior therapist for our kid. So they were working on it at the time. They just didn't tell us, and then they figured it out, right? Anyway, so and so that's been an interesting experience, because Portland Public, like the point of entry for a Portland Public behavior analyst is through the behavior support plan provision of the IDEA, right? So the Individuals with Disabilities Education Act provides for, education services, right? And then if a kid has behavior problems that interfere with school, then the school has to write up a behavior management plan or a behavior support plan that tells everybody how they're going to deal with the disruptive behaviors. And so the sort of point of entry for ABA in school, as Portland Public perceives it, is a behavior support plan. The behavior support plan kind of functions as the treatment plan in the BCBA world and the behavior support plan in the IDEA. And of course we're like, well, okay, tomato, whatever. But the reality, like the sort of byproduct of this is ABA services are only available from Portland Public after for kids whose behaviors are a really significant problem. So the dumpster has to be on fire before anyone will show up with the water. And then the provisions of what effectively is a treatment plan for the school district BCBA is very much directed at managing maladaptive behaviors. And so, the meeting we had earlier in the week with the whole team and districts council and everybody else was like, this is fine, but, at the end of the day, my kid is engaging in maladaptive behaviors because he lacks a certain amount of executive function and focus and flexibility. And your plan is focused on what you're going to do when he screams or throws a book. But, his private BCBA therapist has all of these programs that are directed to expanding his executive function and focus and flexibility. And so you're not skill building, you're just dumping fire, you're dumping water on fires. And at the end of the day, this is only going to be so successful unless you're doing this. So it isn't really the same thing. But there really isn't a capacity on the district level to kind of build this, the skill building aspect into what they're doing. Because again, they've plugged they've plugged in at this behavior support plan in place. And then they deny that, like the Portland Public denies that they don't have enough, their official position is they have enough behavior therapists to meet all their kids' needs holistically, which is math that I don't understand, given that they've got like 900 autistic kids and some behavior therapists. But okay, 6 down? Yeah. So there's that. And so all of that, so Portland Public's trying very hard. I don't know of any of the other districts that are really trying very hard, or if at all, right? So, but Portland Public, their position with respect to the regulation of therapists is, for God's sake, don't throw any more rules at us. And if you try in legislative session, we're going to kill it before we even read it, because we don't want to deal with you people as well. And that is sort of the limit, frankly, on how far we're going to be able to get, I think, legislatively, because last time they wouldn't even talk to us.
Well, I was going to say that I think these are good points, and also that regardless of Portland Public's ability or where they are to decide their process, right? And regardless, there's 3 separate issues, and one of the issues you talk about regards, a behavior support plan, and whether I imagine that some things would come up with, if someone develops a behavior support plan, is that in and of itself, would I say that's practicing ABA therapy? Can someone create a behavior support plan without said to be practicing? 1, 2, how do you develop something good? So how do IEPs generally get developed in a positive and appropriate manner? And then the third is just that our job is to say, as board members, if you are practicing this, we oversee it. And there is oversight for school psychologists are licensed, and there's oversight for that. So there's precedent for that. It's not brand new. Certainly in the Northwest, we are very new to the idea of schools and ABA. It is not something that is unusual, certainly on the East Coast and other parts of the country. So it's evolving. And so I would hesitate to let other people's distress become my distress. And I don't think that should prevent us from doing our job, which is to say we agreed to talk about the licensure and appropriateness, and that we should oversee that. And that includes, in most cases, overseeing unlicensed providers.
I think it's absolutely right. It's absolutely right. I'm just saying we're not going to be able to, we're not going to have much success kind of putting our way into this.
Yeah.
Right? We're going to have to be fairly determined.
Yeah. I'm game. It's fine.
This is Samantha. I actually heard from a school district last year that said they have a carve-out in the legislation to practice ABA without any oversight. That's like direct from a director of student services for a district in an IEP said that they were allowed to do it without any oversight per the legislator. So I will also cite that.
Yeah, no.
If I could just comment, I've had lots of very difficult and direct discussions with Portland Public Schools about this issue. And I will say they use only licensed people for my kid. I don't. So in my discussions with the Board of Psychology, last summer, because I talked to the staff last summer about this also, we just sort of brainstormed issues. So as an example, prison staff. If a prison is monitoring behavior of an inmate, they may very well use techniques that could fall within the definition of ABA. But they're not necessarily doing it for the purpose of treating a mental health condition. They're doing it for the purpose of maintaining, prison discipline. And, I would defer to all of you for how that should be covered. I think their stance, again, this was not an attorney. This was a law enforcement person. This was a psychologist. Basically was, well, that's not psychology because that is maintaining discipline in prison, even if we happen to be using ABA-like techniques. And I think a similar case question for a school would be, if you're doing a point system to reward good behavior for a student, that might technically fall within how you could look at ABA, but you're not doing it for the purpose of treating a mental health condition, you're doing it for the purpose of improving student performance. So I would tend to say that's fine, that's teaching, that's not psychology, that's not an issue. Where I have a really strong concern is use of ABA for the purpose of treating a mental health condition, because that's healthcare. And what I most emphatically don't want is a school coming in and saying, number one, you can't have your licensed healthcare provider doing services in the school, because we're going to have an unlicensed person with no training whatsoever do it instead. That is unacceptable. And with my own son, 2 years ago, we had exactly that problem. They kicked out Kaiser Permanente's licensed staff, and then they had unlicensed school teachers who thought they could do ABA better, who ended up, absolutely creating a disastrous situation for my son, and that turned around like that once Kaiser was allowed back into the building. And that's abuse. That is abuse to deny a kid access to health care that is medically necessary and prescribed by a physician. And that's where I personally draw the line, is that question of health care. And I'm totally happy with schools getting a specific carve-out to say, if we are using ABA as an educational technique that is not focused on treating a child, I'm personally okay with that, as long as they are not preventing kids who need ABA as a medical treatment from getting it. And if they want to do it themselves in their own dime with their own licensed people, and they do it in a manner that is consistent with physician's instructions, fine. If they want to allow the outside provider from the health plan or Medicaid to come in, probably better. But it's got to be a licensed person who's actually doing an appropriate job, coordinated care professionally.
And Portland Public's kind of coming around. For a while they were saying, well, we're doing educational ABA, we're not doing medical ABA, right? And they seem, at least from discussions with council this week, they seem to be abandoning that frankly, fairly shaky distinction.
I have still heard some of that, and I'm now discussing that directly with the general counsel for PPS. What I heard in my IEP meeting a month ago was, I don't need to take from one of your licensees, I don't need to record notes in the ABA service records and data because this is an educational service. And that's where I point back to the letter that you all sent out several months ago and other kinds of things. And that's where I'm having that conversation with the general counsel, who was then working with me to address that.
And the pinch point, right, for the school is staffing, right? I think when they hired DCBAs, they thought they could spread them as thin as they spread school psychs, and then discovered that they're not allowed to, and then that threw them into a level of disarray.
This is Megan. I think one of the main points that I feel like is difficult with this is the fact that there's two different criteria, diagnostic criteria, right? You have the school diagnosis of autism, and then you've got like healthcare diagnosis of autism, and so I think that's very confusing when we're working on, whether or not it's for like health versus educational, and I think that's something we talked about at our last board meeting a little bit of like, maybe it's confusing of like, should this come to us or should this be governed under the Board of Education as far as licensing and stuff like that, because they can license their own people as well when we're talking about speech and PT and OT and those kind of people, and so is that something that they need to govern or is it something that we need to govern?
So two things on that point. First off, in terms of the criteria, the Autism Commission has spent about 10 years working on that, and they did get the rules changed that the education was synchronized with medical. There is pushback now to change that back again. So that is, and it's actually Disability Rights Oregon that's pushing them to change it back, and I don't really know the issues, but it's something the Commission was looking at. The second, in terms of like the SLPs and OTs in schools, historically, TSPC had a separate credential for speech language pathologists working in schools. That was stopped a couple of years ago. So there are a few legacy people who are grandfathered in, but going forward as of, I think, 2017, all SLPs in schools have the same medical license, the same medical type SLP license that anyone else has. And for OTs, it has been like that. Psychologists are the one thing that still stands out where it's different. Actually, school nurses, they have a school nurse certification, but the requirement is you have to be a medically licensed nurse first. So it's on top of rather than in place of.
So and those providers also have state licensure as well as their national certification?
Yeah, so any school nurse also has to be a registered nurse first. And an SLP or OT has to have the medical license from those boards. The only distinction would be a school psychologist, which is still different.
When I'm talking about licensure, not credentialing, like we're licensed with the state of Oregon, but we're credentialed through the BACB, so they have a state-specific license.
Yes, they have to be, so nurses have to be licensed.
Okay.
They actually get a license through the Oregon Board of Nursing.
Right.
Sleep language pathology, the Board of Sleep Language Pathology.
Speech language pathology.
Yeah, that. So it's an Oregon license, yes. And then what was the other one you said?
Occupational therapist.
Yeah, OTs, yeah.
Okay.
There's actual independent boards for each one of those programs. So like you guys are a board, you're not independent because you're one of 16, but it's the same things like what's through you.
Okay, so technically, it wouldn't be outside of our jurisdiction to be licensing people working in the school because there's kind of a precedent with other licensed professionals.
Well, it's just new.
Okay.
It's just new because this is a new group of licensees.
Right.
So it's more about getting the law changed, because if the Oregon Department of Education says every healthcare provider that works in our school district must be licensed.
Okay.
Well, you're a healthcare provider. So, I mean, but that it's new, so it needs to be added to statutes, because I'm assuming right now it says any nurse working in a school must be licensed or registered through the school. And then you say, well, in order to get that, you have to be licensed through the Oregon Board of Nursing. But that's all in law and rules.
Right.
So that's where it needs to be addressed.
Okay, thank you, that's helpful.
Yes, but the Department of Education doesn't have the authority to permit people to practice medicine in the school without a license.
Correct.
And so, that's, I mean, part of the issue here is that the law, understanding of the law has evolved in the last decade, whereas before the McHenry v. Pacific Source case, before AFV Providence, there was some confusion or ambiguity in terms of what exactly is APA. And McHenry v. Pacific Source, AFV Providence, and others clearly established, yes, this is a medical service. McHenry was very specific exactly on that issue, saying, no, this is not an educational thing. And AFV Providence took that further. And so I think prior to that, one could have been legitimately confused. But because the courts have been so consistent and so clear, and DOJ has come out with an opinion right after the A&P Providence case, is medical, which then suddenly upends a lot of expectations schools may have had. And again, they can still practice ABA if they're using it as an educational technique, but they can't do it as healthcare.
And it's, our experience really illustrates from a consumer perspective, and I'm here for, to present the consumer perspective, right? My kid cratered, the school system engaged in 2 months of machinations that eventually led us to where we are. From my family's perspective, my kid's a mess. We've got this huge gaping hole to climb out of. Best case scenario, we'll have lost the school year. And they're like, well, we got there, we're fine. So there's a lack of urgency in the school system, right? That is pretty devastating to kids who have needs. Really, frankly, again, we may recover, but we won't have made any progress. He'll have lost his 6th grade year, and it's not done that we'll recover. I don't know if harm will be permanent or not. And the district's like, well, but what do you do?
It seems it would be helpful and important to sort of clarify and provide some type of oversight for unlicensed people. Certainly, the failure of districts, small and large. My brother, as a university student, my youngest brother is blind. He was there, not provided his texts in Braille. He failed his math course, and then shortly after received a note from the dean admonishing him for not preparing for class. And that university has been sued quite a number of times for failure to support visually impaired. So the fact that laws exist does not mean that people will always follow them or they always do them in the best way possible. But I think any way that we can help to close those gaps and provide at least a venue for oversight seems reasonable, seems within this something important for this board.
To get us back to the place of getting something in the works to kind of bring back SB 135 in a new light with stakeholders in mind, is there going to be, or do we anticipate there being an issue moving forward with getting a stakeholder group together? I know it's that we've discussed in the past, that includes like ODE or includes specific school districts. Now that they have BCBAs and RBAIs in school, I feel like it would be my hope that they would have more interest in moving forward with an actual stakeholder group and being a part of the process of writing a new bill that we'd be able to propose. So
a year ago, the schools were flatly refusing to talk at all. They held a meeting. They specifically forbade me from attending. Think of what you were just hearing about public meeting rules, right? Okay, there we go.
Your one-man exception for the law, except for Paul.
So we had discussions about that. So and they. When we did have the legislation coming up, they raised objections. They flatly refused to talk about it. I had Senator Manas Anderson send the schools a potential compromise. She couldn't get a response out of them either. This year I've begun having more collaborative discussions with a more senior level of management of Portland Public Schools, and so I think that might be a possibility. Brad, if you have any way of maybe nudging people on your end to be part of discussions, whether we can get there or not, I think being a part of discussion would certainly be helpful.
Yeah, this is Brad. I'd be happy to help with that, Paul.
Thanks.
And at the end of the day, the schools are going to play if they don't have a choice or if there's something in it for them, right? And so if they thought we could pass a bill over their objections, then they would come to the table. They didn't come to the table because they were confident that we would get nowhere without their support, and they were right. They will also come to the table if there's something in it for them, right? So if they're billing Medicaid for services and they can only bill Medicaid for licensed individuals, they'll get more interested in licensed individuals, So it's a little disappointing that the waivers stalled out. Not entirely surprising.
It seems from what I've heard in my discussions with different districts that it seems like it's too much of a hassle for them on their part to do the billing piece. However, I think in the past, if they were doing any sort of billing towards Medicaid, it could have been towards like less intensive consultative type services. But if we're doing ABA, even at a consultative basis, it's still far more many billable hours versus 30 minutes a week from an SLP. We're looking at anywhere from, I don't know, maybe an hour to 30 hours worth of services of a BCBA or an RBAI's time. So fiscally, I feel like it would be beneficial for them to be looking into it. And I also think, too, kind of on a different offshoot here, but if we're looking at the model of different services, do we know, any of you possibly know, do SLP assistants or OT assistants come into the school to provide those services, or is it only the SLPs and the OTs? I haven't personally seen SLPAs or OTAs.
This is Brad. Yes, yeah. School districts employ credentialed SLP assistants and certified occupational therapy assistants.
Great. So they're already familiar with a service model similar to that of ABA, where we have RBAIs and a BCBA, right? So there's still the governance piece of the BARB that would be overseeing the RBAIs are just as much within our jurisdiction as an SLPA would be for someone who's an SLP, and whatever that governing body is or regulatory board is for that as well. I think there's probably a lot of what the school district might be looking at is, hey, I have a classroom assistant and we don't have an RBAI here, but we could show them how to do these things and then they could do it. And that, I think, would fall under the issue of, well, if you are saying you're doing ABA but you are not licensed, that's a legal practice of ABA. And I think that's probably one of the big hiccups that the school districts, if they are employing RBAIs, is going to see, because they're probably kind of leaning on the individuals that are getting paid less and that they have more of. And so I think that's probably going to be a big issue. But certainly one that we would want to address with the school districts, if they are employing multiple level professionals on the other service pieces, they should be doing the same with ABA too.
This is Brad. I just wanted to kind of comment that there is really something dramatic happening in Oregon schools right now. Particularly, I see it in the region that I work with, Multnomah, Clackamas, Hood River, and Wasco counties. School districts are looking to employ behavior analysts. Portland Public Schools created, as you know, with HR, they created with Human Resources, created a job position. They require the national BCBA credential. They require, the job description requires credentialing through this board, and they're working to train a number of districts that are employing BCBAs are working to get a number of their paraeducators trained up as registered behavior technicians. So, and just kind of an anecdote here, I facilitate a monthly professional learning community of school-based autism consultant specialists. There's a number now of board-certified behavior analysts in that group. And we had a meeting where I think we had 34 people in attendance, and I asked how many had completed or were enrolled in a BCBA preparation program. Keep in mind, these are all school-based folks, and 15 hands went up. That's a dramatic shift in a short amount of time. So there's this kind of, and there's a similar trend in other states where there's this kind of almost rush to employ. Now, I can't remember who made the comment, but the issue around how to appropriately employ and direct the work of a BCBA in a school-based environment and allow that professional to stay within their code of ethics, that is a whole different challenge that school districts are going to have to work out, because I think that the perspective among some administrators is, oh, we'll just hire our own BCBAs, but that is just the start. Then they have to figure out how to appropriately structure their work that in a way that again doesn't put them in conflict with their code. And I think that's also an issue that folks are grappling with, and we're going to hear and see more about that in the coming months and years.
So I think it's really important that they not be let off that hook. Like I think if school districts had the option, they would give BCBAs 1,000 kid caseloads like they do at school sites, and then go, well, just there isn't much value here anyway. So I think they're kind of in a pinch point now, but I think it's an important pinch point, and I would rather, speaking strictly personally, like I'd rather tolerate the unlicensed providers and let the schools off the hook by giving them the exemption that they may require in order to go along with the unlicensed provider bill.
Yeah. Well, again, this is Brad, and there's a decent amount of variability in the kind of disposition of school districts. Portland Public's obviously the largest district in the state, and they have a policy that they've articulated around BCBAs, coming into the schools, but there are some other districts where they've made a decision. Like I was sitting in a meeting where somebody leaned over to me and said, "We let them in our district. We let BCBAs come into the schools. We just put some parameters around it, and we meet in advance, and we structure it in a way that we have those kind of underlying interests addressed." So there is some variability there, and some districts are just more restrictive than others.
And there's also, we're kind of at the head tip of this sort of mental health sphere in a way too. I represented some families at Pioneer School a couple years ago, and against the school district. And when we were sort of putting that whole thing back together, one thing that the Pioneer staff really wanted was a prescriber to come to the school once every month, whatever. That the population is a very high needs population, and so at that point they figured about a quarter of their kids were homeless, another 30% or so were living in families with significant addiction issues, and so kids had medical needs, like medication needs that weren't really being well managed by the families, and so the staff wanted to make it possible for kids' meds to be managed at school if the families opted in. And, every single kid in that facility is a Medicaid kid for one reason or another, and we've got the CCO system. So I thought, oh, well, this will be the one easy thing I'll do is make this happen, And just as we in the first couple conversations we had, the unlicensed, or the outside ABA provider in school issue kind of blew up, and the district killed that whole, psych prescriber at Pioneer issue because they decided there'd be no outside providers in schools for anybody for any reason, regardless of whatever. And so it'd really be great, I really think the school system and the mental health provider community need to be a lot more collaborative in a lot more different ways over a lot more different issues. And we're kind of at a point where things are sort of coming to a place of tension that is I think it's also important for us to be mindful that it's a much larger conversation.
Okay. Anything else, Will?
So, I think the next board meeting is in July. If any of you have an interest in being involved in sort of brainstorming and working on legislation, let me know. I think most of you know me. I can reach out by email. Like I said, the Board of Psychology, they're legally structured differently than an independent agency. They specifically said they would go out of the way to actually endorse something and ask the governor to do it. You mentioned you're under Patrick Allen here, so I can try and reach out to him and talk to him directly as well, and just make sure that he's aware of this and see what he's able to do. He certainly had a lot to do with this issue when he was at DCBS.
Yep.
So.
Okay. Thank you, Paul.
Thanks.
I'm sorry, this is Brad. I just wanted to, Paul, you also mentioned issues around a restraint and seclusion and possibly looking at that, and I just wanted to say that I think that is a worthy topic for the board to take up at some point.
Thank you for bringing that up again. I think some of these things you could probably just do with administrative rules straight up, and I think that is a great example. Because you already have, I mean, by adopting the ACB rules, you have already adopted rules that touch on restraints, but they're really vague and they are out of touch with what the rest of the state is doing. And I think I would encourage you to maybe put something on your agenda for July that looks at these things and potentially, maybe some of you, and I'm happy to look at it and sort of look at some of those kinds of things to see if there are things that ought to be done by rules, and then maybe you can bring that up in July and get started on that if you decide you're ready.
I have it.
Yeah, and there was Oregon passed Senate Bill 963 that went into effect July 1, 2019, that clarified guidelines around restraint and seclusion by public school entities. So that may be something that is worth taking a look at.
Exactly.
So we'll talk more about that when we get to item number 10. I have it written down. I'm pretty good at taking notes. Anything else, Paul? Nope.
Nope.
Okay.
Thank you.
So, Maria, it is 10:53, and we are going to take a 15-minute break. All right, Maria, are you ready?
Yes.
Okay, so go ahead.
The Behavior Analysis Regulatory Board will now meet in executive session pursuant to ORS 192.6602F, ORS 192.3559A, and ORS 40.225 for the purpose of considering information related to legal advice exempt from the public disclosure at 11:14 a.m. on January 24th, 2020. Representatives of the new media and designated staff shall be allowed to attend the executive session. All other members of the audience are required to leave the room. Are there any representatives of the news media in the audience?
No.
Recognizing there is no news media in attendance, all other audience members are asked to leave the room during the executive session. We will return to open session before taking any final action or making any final decision. We are now in executive session.
Okay, so, yeah.
Okay. The Behavior Analysis Regulatory Board will now exit executive session and reconvene open session at 1:11 p.m. No final decisions were made and no votes were taken in executive session. Members of the audience are welcome to return, and representatives of the media may once again report all board discussions and actions. The Behavior Analysis Regulatory Board will now meet in executive session pursuant to ORS 192.6602F and ORS 675.595 for the purpose of considering information related to cases exempt from public disclosure at 1:12 p.m. on January 24th, 2020. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are required to leave the room. Are there any representatives of the news media in the audience? Recognizing that there is no news media in attendance, all other audience members are asked to leave the room during the executive session. We will return to open session before taking any final action or making any final decisions. We are now in executive session.
Yes.
The Behavior Analysis Regulatory Board will now exit executive session and reconvene open session at 2:37 p.m. No final decisions were made and no votes were taken in executive session. Members of the audience are welcome to return, and representatives of the media may once again report all board discussions and actions.
So now she answers break. What was the question?
Okay, so we're back on regular session, so it sounds like a few people might need to take a restroom break real quick. It is 2:37. We're going to take about a 10-minute break.
Sure.
Does that work? 10-minute break.
Go.
Okay, bye Maria, sorry.
Yeah.
Are you ready?
Okay.
Okay, so we're back on, it is 2:48. We are on the agenda under item number 9. So it is proposed that in case number 19-9334, to issue a notice of intent for a civil penalty in the amount of $3,200 and for the individual to take a 4-hour class that is in person and approved by the BACB on ethics, and that it cannot count as towards their yearly continuing education. And the class must be taken within 6 months of the date of the final order. In addition, the notice will assess the cost of proceedings not to exceed $5,000.
I second the motion? No, I move. I so move.
I second.
Wait, your name?
Marie, I so move.
Brenna, I second.
There you go.
A motion has been made. I'll call the roll. Brenda Lagarde.
Aye.
Yes.
Megan Johns. Aye. Marie McMowen.
McMahon, aye.
You don't have to do last names if you don't want to.
Corey.
Aye.
Samantha.
Aye.
Motion carries. Okay, so now we are on item number 10. So other board business. So one of the things that I wanted to bring up is that our current rules and the reference to the BACB, there might be some clarification that you guys could do on what are restraints and what are not restraints, what in the process of using them, what, all individuals should or should not be doing. So can we have a discussion about restraints and what you guys see the issues and how we might fix that? So go ahead.
Yeah, I mean, so when we get into, so what, do we have, so according to Paul, we have current rules against restraints, but they're vague.
I think and I'm not 100% positive because he's not here to clarify for me, but I think what he's talking about is the fact that we have approved the
BCBA national standards.
Yes. For both behavior analysts and assistant behavior analysts, the board adopts sections 1 through 9 of the 2016 BACB Professional Ethical Compliance Code for Behavior Analysts. So if anybody knows that very well, that'd be great. If not, Maria can bring it up. But here's another thing, is we cannot make decisions today, so just so that everybody understands, because the public has to be aware of the fact if we're going to make a decision. So what we're doing right now is talking about things that we want to address at the next meeting. The other thing too could be that we want a meeting faster than July, so we can make that decision towards the end. But one of the things what I want you to do is talk about, do you want to change, and if you want to change, how we make that change, and then we will get that on the agenda so that everybody knows that we are going to be talking about restraints at such and such date on the board meeting. Does that make sense?
Sure.
So we're not making any decisions today other than the fact of what we're going to put on the next agenda. Okay? Okay. So if you would like to put on the next agenda to have a detailed conversation about restraints, that would be great, and I think that we can do that. But between now and then, if you could do some research about, because obviously everything is supposed to be evidence-based. So any kind of documentation, any kind of research, start sending it to me and to Ann. Probably best to Ann because she'll actually have time to deal with it. Send it to Ann. She can then send it out to all board members, or we can have it all at the meeting, but then go through the evidence and that kind of stuff. So anything that you have related to restraints, maybe review what is currently in the 2016 Professional Ethics Compliance Code and say, this is what it says, here's what I think we should add. So it's more of homework. Does that make sense? Because we can't make any decisions today on it, but we can definitely get it on the agenda for the next meeting. Does that work?
I so move to put it on the agenda.
You don't have to make any motions.
We want you to do that all day.
So we will make sure that is a board discussion item on the agenda, is to talk about restraints. Okay? Were you going to say something?
I was just going to say, can we also talk about, I want to make sure that when we're talking about it, that we have some checks and balances, not just blanket removing the ability to put a child in a restraint.
100%.
Yeah, I don't know.
When and what is appropriate?
Yes. What we could
any kind of research that you have, any articles, anything that anybody has that you want everybody to be able to review, remember we have to do this as a group. So if you know of anything, email it to Ann. Ann will make sure that everybody has the same information, so we're all reviewing the same stuff. She'll make it a part of the material so that the public also gets to see what we're reviewing. Because the biggest thing is when we get to the public comment period, if people have opinions about stuff, we want them to say that. And you need to take that in consideration when you're working on stuff. So that's why we do things like there's a process to everything. That makes it kind of go slower, but the intent of it going slower is you're getting more input. So, but yeah, any research you have, anything that you want us to even remotely look at.
And would that change, we would put that in a rule, or would we change wording?
We can.
We can.
100%, and that will be a decision that you make. If you want to make it so, you can never do A, B, or C. Well, currently your rule doesn't say that. So if you want that, then we're going to have to open rules, put it in there. We'll get a rule schedule going, figure out when you want it implemented, which is then going to change how many meetings you're having and when you're going to meet with us. So, but those are all things that we'll discuss at the next meeting.
So I'm flipping through what's currently on the BACB website, right? And you know, there's provisions about aversive procedures. You know, the mandate to use least restrictive procedures and the mandate to avoid harmful reinforcers. But all of these, you know, kind of beg the question of what the person implementing the restraint thinks he or she is doing, which in my mind is irrelevant, right? There's either an immediate risk that the kid's going to hurt himself, you know, that can't be remedied in any other way, or there's not.
So here's another food for thought, thinking about that same thing, is when you're doing your homework, look at, because in our rule, we adopted sections 1 through 9.
Yeah, this is important.
So if we are going to unadopt section 1 through 9, we need to figure out what sections we're not going to have, because it sounds like you might want to not have that section.
Well, I think we could just add to it, right? Like, because all of this stuff is perfectly good. It's just that this is so clear that we shouldn't, in disciplining somebody for doing an inappropriate restraint, we shouldn't have to be like, well, did you think you were doing a punishment, or was it, you know, we should just be saying, you know, was the kid a danger to himself or not?
It's a question that wouldn't be asked during the investigation.
Yeah.
And an investigation by the office or wherever the person is working, or DHS.
Right.
It'll come up.
Right.
So, but they want to make it clear in rules, so you don't,
that.
so that we don't have to ask that. They know.
Right.
Yeah.
But
So
we still have to.
412 or something
100%.
that would say, you know, in addition to also.
But it's just your
restraints
homework,
absent
yes.
that. And there's all these, I mean, everybody's got a policy and a procedure.
Well, and I think something like having them submit a crisis plan, like you have to have a crisis plan on file in order to be able to issue a restraint, and that crisis plan has to have X, Y, Z.
That'd be great.
Statement or something like that, and you maybe need, I think, regardless of whether you're home community or in a clinic setting, having maybe one other adult, it doesn't have to be another analyst, but someone else being present when a restraint's being used would also be amazing. I feel like that would be doable. Corey, do you agree that that would be doable regardless of environment?
So we're talking about now, we're saving this for the next meeting.
Right.
That's your homework.
Yeah.
So gather that information. If you know of some sort, and you can, for one, if it's your company policy, you can cover up the company logo and all that stuff, and then just copy like the verbiage and get that to us so that we have some starting points. We don't want to, for one, we don't want to be here all day and have to start from scratch. So if we got some good documents that we could start, because we can actually start writing stuff because we know how these are written.
Yeah.
So, but get us that information, and that will be our homework, because we're going to have some deep, in-depth conversations about what we do and don't want in rule at the next meeting.
Right.
Yes. So, everybody okay with that? That's some major homework. We'll get on that. So there was another thing that I needed to talk about. Where's all my notes? Does anybody have anything they want to say? I'm trying to remember what my other conversation was about. I usually take really good notes.
Paul had brought during
Well,
the
we're going
public
to talk
comment
about
period.
whether or not, like the question of whether we wanted to write a rule about whether or not, about whether we're requiring ECBAs to only use registered, registered interventionists. That was the big topic, I think, that was saved for the open session.
Yes. So as we know that we have statutes that talk about it's a Title Act. So you can't call yourself blah, blah, blah. However, you as a board get to, somewhere in here, it defines what you get to do. And one of the things that you get to hear a meeting statute, and Heather can probably look at it a whole lot faster than I can, but the board so the board shall adopt rules to establish guidelines for the professional methods and procedures to be used by individuals who are licensed. So the board gets to decide what analysts and assistant analysts can do for their professional methods and procedures. The office then gets to decide what the interventionists get to do. Weird, but that's the way it's written. So that gives you the right to make rules that tells analysts and assistant analysts how they do things.
And so the questions that we were wrestling with were, would requiring analysts to only use registered interventionists impact access to care, and also the general question of, the magnitude of the problem that we're trying to solve and other avenues, to solve it, and the availability of those avenues. And so we were, as I mentioned previously, we've always sort of thought that at some point we would be asking the legislature to implement a practice act. It was just a question of, at what point the market and the profession here in Oregon are mature enough, and the stakeholders are sort of focused enough to do that. If we did that, then obviously, this probably would no longer be a problem.
Does that mean, so I know we were talking earlier about when Paul was here, SB 365 sunsets next year.
Yeah.
We would basically just be making revisions to that for resubmission.
Yeah, it'd be pretty profound revision, but yeah. So the reasons that SB 365 is not a practice act are the BACB was being really difficult. And when I say difficult, I mean that they would look through our draft statute in which we're creating a freaking profession in the state and threatened us to us for trademark infringement when they thought that we were using a term that they believed was a trademark of theirs. And just that level of unhelpful. And because they were being so unhelpful, there was a lot of distrust in the larger community and a lot of unwillingness to hand BCBAs specifically and the BACB generally any authority really. And so in order for this to work better this time, the BACB would need to, be more goal-oriented, I'm going to say. And ORABA would need to be pretty focused, and they would need to stay on the same page, because in the past, various legislative efforts have run aground when ORABA has taken a position and there's been a change in leadership direction or God knows what, and then ORABA switched positions and then we're kind of done. So that's really the thing, right? It's taking the time and doing the legwork that's necessary to get all the stakeholders in consensus and then help them maintain consensus through the long and frankly very difficult legislative process. Keeping in mind that now we've got the schools that will kind of freak out about this, and so can we even get them to the table? If there's ever a profession that needed to be well regulated, it's this one. Really honestly, right? These are very, very vulnerable individuals that are being served, and and distressed families, and if there's ever a place that needed a practice act, in my opinion, it's always been this one. It's just a question of whether and how we get all the stakeholders to come to the table and keep saying the same things for 10 months, which we've just never been able to pull off.
So within the parameters of the rules, which is what we're talking about, so as you mentioned, so my understanding is we stay within those guideposts of it doesn't affect access and it doesn't sort of become a practice rule that we're thinking about just what we're thinking about, sort of in safety and supports for kids, that's the focus, and I would agree. And so I think trying to figure out that there's the two steps, that think about how do we move forward with practice, and then how do we write the rule to the best we can with those parameters.
I mean, in my, political opinion, if we want to take a Run Under Practice Act, then we don't want to solve this problem with this kind of half-assed solution.
Yeah.
Because we're going to want to point to that problem to keep people at the table,
And this is Sylvia, and you have to remember too that, again, it's a Title Act, so that means you just can't call yourself a registered interventionist, because you can still be and do the work as long as you don't call yourself that. So and you can also do ABA therapy as long as you don't call yourself a licensed analyst. So
in my mind, if we think that we're, coming up on ready with the SB 365 sunsetting to take a Run Under Practice Act, then we should not avail ourselves of the half-assed solutions under the current statutory construct, right? If we don't think that we can take a Run Under Practice Act, then we probably should do something half-assed, because what else are we going to do?
I wonder though if it's also possible that you write the rule and it's not complete. It doesn't totally solve the problem, which to me then highlights the need why there should be a practice act. Say we've already tried to remedy this with a rule, and that's not been effective. So clearly we need a practice act, or that we see it as this is step one of 2 or 3 or 4,000. That we need to take to get where we want to be. So. Yes, my concern would be that if someone says, well, why are you doing this practice act? Because it seems like you're already trying to handle the rule, and you've got to start where you are.
I mean, my official prediction, my genuine opinion, honestly, is that the school's the biggest problem with practice act, like the biggest impediment now. It used to be the insurance carriers, and then but now it's the schools, definitely. And so, from a legal perspective, there are 2 laws that would address the provision of ABA services in schools. And one is the IDEA, and the other is the American Disabilities Act. And so I've filed 2 lawsuits now, one against Gresham and one against Portland Public on behalf of my own kid, asserting a right to receive ABA in school under the ADA. And the school districts just hate this. And they've moved to dismiss the Gresham case, and it's still sitting on some judge's desk. And then PPS just moved to dismiss my case, and it's sitting on some judge's desk. And if I win either of those motions, my hope is that the school districts will really start to get serious, because they'll start to recognize that families can force them to accept ABA in schools. And that will kind of bring them to the table. And I would hope that if that happened, then they would come to the table in a very constructive manner and we can hammer something out. Other schools?
Yes.
This is Megan, and I feel like based on the hurdles that potentially might come from trying to issue another practice act, not that we should go that direction, but I'm wondering if let's say a motion gets put into place and then it gets denied again, and that whole process takes so long, putting something in a rule might be beneficial in the interim, even if it's not going to catch everything, just so that we have something while we're in this holding pattern of the potential next step.
Yeah.
This is where I agree.
This is Sam. I agree. I just am not sure how we get past the fact that not limiting access to non-licensed interventionists, because I think regardless of the intention, the consequence is that we will be. So I'm not sure how we write a rule that doesn't do that.
This is Megan, and I think being clear with maybe just limiting it to, because I feel like within ABA agencies currently, not other practitioners that are potentially doing the ABA, but within ABA agencies, I would say most companies are having most of their interventionists, if not all of them, already having Oregon licensure. Granted, that's not going to cover the people that we aren't talking about, but I don't know if one potential one, this wouldn't be in the rule, but I think one of the biggest hindrances I hear about from ABA agencies in general is if they don't have their interventionist license, often it's because the process to get licensed can take longer than they anticipate. So it can be up to 3 months. If they mess up their paperwork, it can be up to 6 months. So that's creating, if they don't have the interventionist work with them prior to receiving, then they are limiting access, right? Yeah. So if we shorten that process, that could potentially continue the access. And that's solely within ABA agencies, not outside, like we wouldn't be addressing educational system or anything like that. But I don't know if that's something that you look very confused.
Oh, I'm listening.
Is it HLO taking 3 months to get them
So
processed?
this is what I'm hearing is happening is I'm hearing that there's maybe just one person handling a lot of the paperwork, which is, I get the constraints of finances. And what's happening is sometimes there'll be an error in the staff's paperwork, but they don't get notified until they contact them, and then the staff aren't readily contacting HLO. And so then it'll go by 3 months, and then we're like, what's going on? And they're like, why don't you give them a call? And I give them a call, like, oh, you're missing X document. And so then they're like, oh, crap. And then they have to put it in, and so it's just a long process. Or there's been a couple of instances I've heard about where documents get lost, which, I mean, I feel like it's every office in general, potentially documents are getting lost, but then their background check is expiring.
Yeah, it only lasts 30 days.
And then you have to resubmit everything, and so those are the kind of the concerns that I'm hearing about from a provider standpoint, in terms of, like, I just had my boss at Positive Behavior Sports ask, like, hey, we're waiting on this paperwork, can we have her start? And I'm like, I wouldn't. But she's like, well, I reached out to the BARB, and they, reached out to HLO, and they said, well, here's our rule, this is what we have, that they just can't call themselves that, which is exactly what we've been talking about. But I was just like, I still wouldn't have them start until they get their license. But it means that we have potential staff that are ready to work, and they can't work, and then we can't start clients with services because the staff can't work.
These are not the set of people who can kind of sit there and wait to start a job for 6 months.
Exactly, and then we lose staff.
I think part of what you're highlighting, this is Marie, is that that hindrance is not because of the rule, it's because of red tape. It's because of an inefficiency within the system. It's not due to the rule. So no offense to the state, but
this is Megan, and my thought is, if we're going to put a rule in place that says that you can't practice, then I think we need to help with that process.
Sure, right.
If we're going
it's grandfathering or doing something. Yeah.
Or like, I know Washington State has something like, once their application is submitted, and they have a background check, then they're able to do provisional. So as long as they're supervised while they're with a client, then they can provide services.
Sure.
Conceivably, we could write a rule. I'm not recommending this, or I'm not expressing an opinion, but like we could simply say something like, you've got to, your people have to apply within X of starting, or something like that.
That seems reasonable.
Yes, there's no law that says they have to have a license to be able to do it.
Yeah.
Right, but if we put something in the rule
that says
that's
licensed professional does.
Yeah.
And I can tell you our end of what some of the frustrations are is that legally we have to talk to the applicant. We cannot be talking to the employer. Even though the employer is the one that filled out the paperwork and paid for everything, our communication has to be with that individual, because that individual is getting licensed. So that's usually where the slowdown occurs, because we then call and email that individual. They're not looking at their email, they're thinking their employer took care of all of it, and we can't. We usually will CC the employer as a courtesy to say, hey.
Yeah.
But that's usually what happens when it takes a little too long.
Okay, that's good to know.
Because legally, that person is who our contract is with. Because we're issuing you a legal document, a legal piece of paper. So that's usually what slows the process down. And that's Sarah, obviously, everybody left. But Sarah that's usually what's going on with Sarah. Because the companies will call and Sarah said, well, I emailed Jennifer Smith, and here's what I needed, and I never heard back from her. And then the employer goes, oh, Jennifer Smith, why didn't you do this? That's usually what slows it down.
Okay.
Yes. and we'll get a big packet. So like, we'll get a big old packet in the mail that has like 10 applications. Because it's usually the employer filling it out. But then we have to, each individual person has to be contacted. Anyways,
Yeah.
doesn't mean that we do everything 100% accurate either.
Yeah,
I'm just saying.
Obviously, the staff should make sure they have all the correct paperwork before they submit it as well, but there's lots of different moving parts.
Yeah, and yeah. And a lot of new offices coming in, and you know, some of the offices that have been around and submitting stuff on a regular basis know exactly what we're looking for and what the issues usually are. So do we want to continue having a discussion about this and actually get it on the agenda at the next meeting, or do you guys want to wait a little bit to see how session goes?
I mean, we're not going to do short session. We're not going to do anything in short session.
Nope.
We're not going to do, no, we're talking.
So if you wait until you see how session goes, you're waiting until summer of 21, which we're already in 20, so it doesn't sound like it's not that far away, but that's your guys' choice.
You know, it'll take, I mean, I've been astounded at how hard it is to get something through the legislature. Astounded. And, you know, I mean, and Paul has endless enthusiasm and energy to keep submitting, developing concepts and running at them, and I kind of ran out of energy on this score to a large extent. Like, I'm still suing people. I just can't handle the legislative process like I did for a while. So, so yeah, like it'll require some will out of Araba and some energy, and some patience for what's a long process. Like, if we're really going to take a run at replacing SB 365 with a Practice Act, like, we kind of do need to get rolling. It'll take that long to gather consensus, honestly.
Right.
So the next steps might be going back to, Araba, talking, I don't know, if you want to talk to the BCB. Yeah, and just seeing, if that's where people's heads are at, if this seems like something that they can kind of get together on and focus on and, maintain some attention on. What they've done before. Again, it's been, like, what happens, and I mean a little flippant, but what happens is you go through a process and you end up with language, and and then you find something that language that you're running with that's not great, and you're like, wait a minute, this is not great, fix my thing. But every stakeholder has a thing, if you mess with this, you'll either piss them off because they like the original language, or you'll embolden them to ask for their change. There's this like inherent level of imperfection that kind of accompanies a bill through the process, and what always seems to happen is that at some point someone gets unhappy with their level of imperfection and they just bail or change their positions on the entire enterprise. So I'm saying Araba changes his mind, and I'm making it sound flaky. They have legitimate issues, or they have in the past. They just don't seem to really understand that anything that gets through the process is going to be a little sausage-like. And if they decide that they can't live with sausage, then we're just not going to pass anything, because it's all kind of a mess.
And so you're referring to taking rid of practice.
Yeah.
And so what is our decision about the rule, or is the question that you'd ask, Sylvie, should we keep talking about the rule, or
That's up to you.
Until after?
I'm just asking you what you want on the agenda for the next meeting.
So I'm suggesting that maybe we put it on the agenda for the next meeting, and between now and the next meeting, we go to our respective contingencies and kind of figure out if we think this is going to happen. Like, if we're going to come up with a political will to take a run at this, and then we bring that understanding back to our next discussion and decide what to do from there.
And Megan, you said the Oraba meeting is tomorrow. Brad and I have our Autism Commission meeting next week. So it would be a good thing for us to bring up at that time too, because I know the commission has wanted to have some part in the stakeholder piece in regards to, what Paul has brought up with us here today. So hopefully if we can kind of get all of our agencies together, then we'll really have like a better steam train moving forward this time around.
We have to know, like, are we going? Or are we,
yeah.
Because, let's not bother trying. Let's just
Or address specific concerns if they're addressable.
Yeah, so just that, like, are people gonna be like, I don't know, or are they gonna be like, yes?
Okay. Anything else? So I've got two major things on the agenda. So you guys are going to talk about restraints, and you're going to talk about creating a rule that analysts and assistant analysts can only supervise registered interventionists. Okay, everybody's got their homework. Just email, and if you forget to email Ann, just email me. Just get one of us something, and then we'll take care of getting it out to everybody and getting it included in the record and all that kind of stuff.
And what, Marie, can you remind me, what were the other topics that Paul had brought up during the public portion of the meeting earlier? So those were two parts of restraints.
He has a list
Licensing
of
organizations.
Yeah, he's a list of various and sundry things going on around the level of behavioral health.
Licensure, the organizations, the offices that practice inside.
Yeah, and a lot of things that ABA, the BCDs aren't listed on, which or BARB is not listed on, which should be. It means that he has a laundry list.
Mm-hmm. And he emailed me so that I wouldn't lose track of all the umpteen million things that he said.
Okay.
So Ann had to leave because she had to go to a dentist appointment, and Heather had to leave because she had another appointment. So, but I did touch bases with Heather, so she's going to talk to the AAG from the psych board and just talk about, what do they say, what do they think, because ours is just a title act, so it's going to be hard for us to say, hey, you can't be doing this, when we have no law that says you can't be doing this. But if they have a law that says that you can't be doing this, so anyways, obviously we don't want to be sending out a letter that's,
Sure.
anyways, so they're going to talk.
And that's one of the maybe better interim solutions, right? Is a psych board sending out a letter saying, you're like ABA is psychology, generally speaking, and you've got to have a license to do psychology, and their license will work, but you should go get one.
Yeah, and we'll figure that out. So in addition to that, I told Ann to listen to the recording, because hopefully they record their board meetings, and it's not just notes. Because if it's just notes, that's going to be a little tough for her. But I told her to listen to it, do the research, blah, blah, blah. The other thing I told her to do some research on, and depending on what she finds out, we may add it to the agenda also, but it's the behavioral health. So she's a part of a group that talks about behavioral health and trying to encompass everything. So we're part of public health, which obviously public health is that your health departments that are out there, blah, blah, blah. So we have access to a lot of people, which is really good. So she's going to do a research on that. So she's going to figure out exactly if there is a list of behavioral health people, how do you get on the list? How are interventionists or either an analyst or anybody like that talked about? How do we include, so she's going to get into that research. Because that was another one of Paul's conversations.
That was another one.
Mm-hmm.
That was on Paul's list.
Yep. And I already know about the whole potential legislation. I already knew that because obviously every 2 years Paul and I work together so far. And so I will be maintaining, interest in watching that kind of stuff. So if you hear of anything, just let me know, but I'll usually already know. One of the things that Paul's great at is saying, okay, here's the verbiage that we've come up. Will this work with you? And we'll sit down and say, you might want to change this word to mean this. It's not intending to change the intent of what he's trying to do. It's just making sure that it will fit with all this other stuff. Sure. So, what are the other things? Talking about licensing of facilities. So if a facility was to be licensed, that's kind of that behavioral health department. So if you're going to be doing behavioral health and you have to have a facility license, how do we then get behavior analysts into that mix? So that will be that conversations that Ann has with that group. Because we can't regulate any kind of facility. We can only regulate the individual, unless, of course, the statute changes. But so that will help answer that question, is trying to get, how do we get this, everybody all on the same page kind of thing. He talked about seclusion and restraints, which we already have that on the agenda. School-based, we already kind of talked about that. So we can't force, obviously, the schools to do anything. So we don't have that authority yet. Again, it's trying to deal with, I think we might know a whole lot more here in a year or two. Things might change a little bit, depending on how things flush out.
The schools should hopefully have to just pick a side and decide what their position is, and and then hopefully they'll work collaboratively to figure out what they want to do.
Yep. So did that cover everything, I think?
I
It's
just
been a
wanna make
long
sure that-
email,
yeah,
but I think I summarized
chance
it
to
all.
talk about that, yeah.
Yep. Yeah, and you can talk about the upcoming sunset and then the potential future legislation. So, okay? You guys need to start needing to start 7 in the morning. Jeez Louise. I'm just kidding. I'm kidding. I'm totally kidding. So I think we'll have, I have a whole bunch of notes here, so I'll put it in an email to Ann. And then Ann will listen to the recording, because Maria obviously has the recording, so she can listen to the recording for this end piece to make sure that she has the agenda and everything on there, and then knowing that you're going to be sending her research and all that stuff, because she obviously didn't hear that. So, anything else that you want to talk about before we adjourn? Okay. I'll also have Ann email Brad. Brad, when the recording is up on, so Maria, will you make sure and let Ann know when the recording's up on the website? And then have her email Brad so that Brad can then listen to the end, or listen to, you won't be able to listen to the executive session, but listen to the end of the board meeting so that he's up to speed on homework and what we're going to be talking about at the next board meeting? Okay, perfect. Because he might have some great information too, especially when it comes to some sort of company policy on restraints, because it sounds like he does a lot more with schools.
Yeah.
So he might have some good starter language that we can look at.
Yeah.
So, yeah. Okay, anything else? Okay, so on your green sheet, she's learning.
The Behavior Analysis Regulatory Board meeting is adjourned at 3:25 p.m.